I won't say Judge Eileen Cannon in her authorization to release part 1 of Jack Smith's report in the context of the prosecution of Donald Trump, or the investigation into the prosecution of Trump for the election interference case. I don't think she violated her oath. I think she's had a well-reasoned judgment, and I disagree with her on this. And I read that. I didn't thoroughly read it. And Encryptus, if you're watching this, give us the link so that people can access your AI programming summary of that report. Unfortunately, I haven't been able to actually fully flesh through the summary, but I did sufficiently skim through the report, which adds nothing, changes nothing. There's nothing new by way of incriminating evidence in it. It's just more of the headline shite that the MSM wanted in terms of Trump's big, bad, undermining the election nonsense. Let me get this out of here so we can see it like that. There we go. Now, I know a lot of you want me to enhance. Delivery by hand. U.S. Department of Justice, Jack Smith, special counsel. Is he not legally required to remove that? Since Judge Eileen Cannon determined that he was never lawfully appointed as special counsel, and that it's citizen Jack Smith, not special counsel Jack Smith. How the hell? I put out a tweet, and I like it because I know when a tweet is good when it gets traction. How the hell did a man who was not lawfully appointed to the position get authorized to release the report that he prepared in a prosecution that went nowhere, in the prosecution to which he was not lawfully appointed as the special counsel? How the hell does he get authorized to release the fruits of his unlawfully appointed poison tree? I don't have a good answer for that, other than to say, well, they spent millions and millions and millions of dollars on this report. They sure as hell weren't going to let it go to waste, much like the Mueller report. All right, back to this. Delivery by hand to another man who deserves to be in jail, the Honorable Merrick B. Garland. Okay, final report of the special counsel under 28 CFR. It's statutory. Doesn't matter if he was not lawfully appointed as special counsel. The statute that applies to what otherwise had to have been a specially appointed lawful counsel applies nonetheless. Okay. In the fall of 2022, former President Donald Trump was subject to 2 separate criminal investigations of the Department of Justice. The first was an investigation into whether he violated the law to interfere with the transfer of power following the 2020 election. The second focused on highly classified documents. I'm skipping over this because we don't. On November 15, 2022, Trump declared his candidacy to unseat President Joe Biden. Yada, yada, yada. Okay. On the day I was appointed, unlawfully, I pledged that I would exercise independent judgment, bullshit, follow the best traditions of the Department of Justice. Yeah, their best traditions are persecuting their political rivals, and conduct my work expeditiously and thoroughly to reach whatever outcome of facts and law that the facts and law dictated. Bullshit. With the aid of an outstanding team, that's what I did. It sounds a lot like, what's her face? Fannie Willis. Attorney General Edward H. Levy, who assumed the department's helm in the wake of Watergate, summed up those traditions. Oh, yes. They pat themselves on the back. They're such good, fancy, important, lawfully people. Address, I don't care about this. I have been a career prosecutor in local, national, and international settings over the last 3 decades, working shoulder to shoulder with hundreds of prosecutors in that time. The prosecutors and staff of the special counsel's office are, in my estimation, without peer in terms of accomplishment. He delivered it by hand. He delivered 2 things by hand. The masturbation that he's giving himself right now. More importantly, in my book, they are people of great decency, yada, yada, yada. Staffed by some of the most experienced prosecutors, my office operated under the same department policies and procedures that guide all federal prosecutors. The regulations under which I was appointed, yada, yada, yada. It was more self-serving crap. The department has long recognized that proceeding with uniformity of policy, it is necessary to the prestige of federal law. Our work rested upon the fundamental value of our democracy, that we exist as, quote, a government of laws and not men. John Adams. Okay. When I assumed, I'm skipping, this is all just verbal diarrhea to pat himself on the back. When I assumed responsibility for the matters you assigned to me unlawfully, I came to the work with no preconceived notion of what just outcome of the investigation would be. Bullshit, you lying scumbag. This is the same. They falsified evidence in the classified documents case. He's going to tell me they didn't have a preconceived notion of what they needed the result to be. So it's just the only this works on nobody. Democrats know it's a lie, they just like it. Republicans know it's a lie, they just don't do anything about it meaningfully. And the people know it's a lie, and there's nothing they can do about it. I was not yet familiar with all the relevant facts and had not yet researched the relevant law. Depending upon what investigations revealed, I was equally comfortable closing the investigation or moving forward with the prosecutions in one or both matters. Luckily, I found that there was good reason to go with both, even though both ended up getting tossed or not followed through on. As directed by the principles, I made my decision in these cases without regard to Mr. Trump's political association activities or beliefs, bullcrap, or the possible personal and professional consequences for me. Oh, no, you did. Yada, yada, yada. While I relied greatly on the counsel, judgment, and advice of our team, I wanted to be clear that the ultimate decision to bring charges against Trump was mine. Oh, he's such a hero. It is a decision I stand fully behind. To have done otherwise on the facts developed during our work. Yeah, they were developed all right by you. But if I had not moved forward on that photograph of the classified documents splayed about the floor of Donald Trump's Mar-a-Lago that we put there and put cover sheets on, I would shirk my duties as a prosecutor and public servant after nearly 30 years of service. That is a choice I could not abide. This is so nauseating. It's unbelievable. It is equally important for me to make clear that nobody within the Department of Justice sought to interfere with or improperly influence my prosecutorial decision-making. While we are not able to bring this case, this might have been the more important part. Okay, nor you. Did you make any? No, you never did. You're clean. I'm smart. I respect my oath. I'm good. I did everything properly. Here's a letter confirming it because I just drafted it to you, and you did nothing wrong either, Merrick Garland, who belongs in jail. While we were not able to bring the cases we charged to trial, I believe the fact that our team stood up for rule of law matters. Bull crap. I believe the example of our team set for others to fight for justice without regard for personal cost matters. The facts, as we uncovered them and manufactured them in our investigation set forth in my book, experienced prosecutors know that you cannot control outcomes. You can only do your job the right way for the right reasons. I'm such a good man. I conclude our work confident that we have done so. Yada, yada, yada. Accompanying this letter, I'm providing you a confidential report explaining the prosecution and declination decisions reached by special counsel. Though not required prior to finalizing the report, my office provided an opportunity for counsel for Mr. Trump to review both volumes. Oh, and he didn't do it. After their review, counsel for Mr. Trump wrote a letter to you, and we have provided a written response, both of which you will find in the report. With the report, my staff is complete. I resign, and I'm going to hope for a pardon from President Joe Biden before I leave office. Okay, and then you got the final report. Let's just go down here for 1 second. This document is so bloody long that okay, forget it. Oh God, what did I just do here? All right, whatever. That's the stroking on the back intro to this document. I'm just going to focus on it. It doesn't say anything new. So there's anybody pretending there's some. The whole point in releasing this is it changes nothing. It reveals nothing new. It's just a way for the DOJ to falsify, justifying their corrupt, unlawful decision to prosecute Trump not once but twice. What I found absolutely freaking phenomenal. Set aside the fact that Jack Smith was never lawfully appointed, according to Judge Eileen Cannon, and therefore this report is prepared by a citizen. It's worth nothing. This is the wrap-up smear in this document. This is the Nancy Pelosi wrap-up smear. It's disinformation laundering in real time, and you wonder how they do it. Other charges here. The office considered but ultimately opted against bringing other charges. This is against Donald Trump. One potential charge was 18 U.S.C. 2883, sometimes referred to as the Insurrection Act. Remember this whole insurrection? The whole insurrection, nobody was convicted. Nobody was charged, not even the guy they tried to disqualify from the ballot for insurrection and impeach for insurrection. Why didn't they do it? Listen to this. The act provides, quote, whoever incites, sets foot, we've read this before, so you know what it says, sets on foot, assists, or engages in any rebellion or insurrection against the authority of the United States or the laws thereof, or gives aid or comfort thereto, shall be fined under this title or imprisoned for not more than 10 years, or both, shall be incapable of holding office under the United States. This was the provision that Colorado sought to use to strike Trump from the ballot. They just argued it was self-executing, and you didn't need to actually go through the process of charging, convicting, or having Congress do so. Unbelievable, actually. So they say, okay, look, we thought about it, and we didn't do it. Why? Cases interpreting Section 28.3 are scarce and arose in contexts that provided little guidance regarding its potential application in this case. So, how do you expect to get cases if you never take the first case? Okay. What was the second part of this? It was this one here. Look at this. Here at the end. To establish a violation of Section 2383, insurrection, the office would first have had to prove that the violence at the Capitol on January 6, 2021 constituted, unquote, insurrection against the authority of the United States or the laws thereof. Yeah, it's kind of called satisfying the wording of the law. And the fact that you didn't do it probably means you didn't even have any reasonable grounds to suspect that it happened. Courts have found or described the attack on the Capitol as an insurrection. All right, which ones? Which courts? Anderson versus Griswold. Griswold. Jenna Griswold. Does that name sound familiar? The psycho biatch from Colorado who, oh God, Crazy Eyes. Google her Crazy Eyes. Yeah, that's the one where they kicked Trump off in a split decision at the higher court from Colorado, where even some of the Democrats were saying, like, I've never seen anything like this in my entire life. Oh yeah, the one that the decision got struck down unanimously by the Supreme Court of these United States of America. That they're citing the lower case that was subsequently reversed unanimously by the Supreme Court as a court that has found or described the attack as an insurrection. We don't know which one they're saying, because in that decision, I don't know if they found or described as an insurrection. But you know what I don't give one sweet bugger all about? Any jackass, even if they're a judge, who described it as an insurrection, because that's not a legal finding. Let alone the fact that it came from a decision that was subsequently overturned unanimously by the Supreme Court. So relying on bad law, even relying on bad law, we didn't bring charges, although some courts, bad law, have called the events of January 6th an insurrection. Good for you. The Colorado Supreme Court found that Mr. Trump engaged in an insurrection, and in the terms used by Section 3 of the 14th Amendment, federal courts in the District of Columbia have also used the term insurrection to describe the attack. Oh, that's good. Relying on bad law to explain why they still didn't charge him, even though, according to that bad law subsequently overturned, they could. It's the wrap-up smear of the highest order, just to get this crap back out into the narrative a week before Trump takes office. Maybe dirty Ratskin McRaskin is going to do something with this. And maybe they're just going to use it in the wake of the convicted felon status now being solidified by Judge Merchant to do God knows what. But they are criminals of the highest order. Yeah. How does an unlawfully appointed special counsel release the report the unlawfully appointed special counsel prepared in the context of a prosecution to which he was unlawfully appointed special counsel? It makes sense when you understand that we're governed by corrupt scoundrel nincompoops of the highest order. Sadwin's raging. Looks like he's given up beer over in our locals community. They're not giving up beer to us, but all right. Encryptus in the house says the link to the articles that links to all the summaries and other articles written today on the two reports. Now I'm going to share this with absolutely everybody before we head on over to vivabarneslaw.locals.com. Encryptus, transforming special counsel into analytical articles using custom GPT, and it's all here. It's amazing. Encryptus does just amazing stuff. Encryptus, shout out your stuff and I'll highlight it up here. Thank you very much.